Did you know that not all trademarks are created equally? Certain trademarks are stronger and easier to protect than others. So when you're choosing a trademark for your business, you need to differentiate between strong trademarks and weak ones. Here's how. Hey friends, welcome back to my YouTube channel. I'm Faith Mitton, an attorney on a mission to simplify trademark law for entrepreneurs and business owners so that they can better understand their legal rights. Here you'll find tons of content to help you learn how to navigate the crazy world of trademarks and to stay on the right side of the law. Today's topic is one that no brand owner can afford to be ignorant about if they're serious about protecting their trademark rights. Trademark lawyers refer to this topic as the distinctiveness to descriptiveness spectrum, but it just boils down to this: how strong is your trademark? Let's back up for a second and define what a trademark is so that we are all on the same page. A trademark is a type of legal protection for a business's brand identity, the things that help people to recognize that a business is the source of particular products or services. The things that are typically registered as trademarks include names, taglines, and logos, but the trademark universe is pretty huge, and you can also register trademarks for things like building designs and colors and scents and sounds and hashtags and domain names. But the whole point of registering a trademark is to claim your exclusive ownership over your brand identity and to prevent your competitors from adopting a similar one. But whether your application to register your trademark will be successful depends, at least in part, on how strong your trademark is. That's because stronger trademarks have an easier time getting approved and are easier to protect against infringement than weaker trademarks. Everything that is or could be applied for as a trademark falls into one of the following 5 categories depending on their strength. So let's look at each of these 5 categories individually, going from the strongest down to the weakest. The first category is for fanciful trademarks. Fanciful trademarks are made-up words that don't have any meaning in any language. So if a word has never been used by anyone else before, that's going to be pretty unique. Examples of fanciful trademarks include things like Xerox and Kodak. Before these companies came on the scene, nobody was using those words. So these companies literally changed our culture by adding new words to our language, and in doing so, they created a really unique brand for themselves that was very easy to defend against infringement. The second category, right underneath fanciful trademarks, is arbitrary trademarks. Arbitrary trademarks are those which use existing words but in unexpected and unpredictable ways. So, arbitrary trademarks don't have any logical connection to the products and services they are used to promote. Because of this, they are also really strong trademarks because they have this ability to change our culture by influencing the way that we use language. Great examples of arbitrary trademarks include things like Amazon for online retail services, and Apple for various technology products and services. The Amazonian rainforest has no connection to e-commerce, and apples don't have any connection to technology and phones and systems and such. So arbitrary trademarks like these also tend to be really strong, really unique, because the competitors of companies that have arbitrary trademarks are very unlikely to adopt ones that are similar to those trademarks. This is again because arbitrary trademarks are sort of changing our culture. They're changing the way that we use words and are helping us to ascribe new meanings to words that we already know. The third category is suggestive trademarks. These trademarks rank under arbitrary trademarks in terms of strength. Suggestive trademarks are those which use existing words in non-obvious ways that are really creative. And these trademarks imply a connection between the products and services they're used to promote without spelling it out. These are also strong trademarks, although not as strong as arbitrary or fanciful trademarks, because they hint at the punchline and require some imagination and creativity to understand. Great examples of suggestive trademarks include chicken of the sea for tuna or Fitbit for wearable fitness tracking devices. We all know that chickens don't live in the sea. So by using the trademark chicken of the sea for its tuna products, this brand is implying that tuna is as versatile and affordable and familiar as chicken. Fitbit similarly suggests or implies what the product is by combining these two syllables, fit, which represents the word fitness, with bit, which represents a small technological device to let people know that this Fitbit is a device that will help you to keep track of your fitness goals. So as you can see from these examples, suggestive trademarks are the hallmark of brands that want to be memorable and create a lasting impression by being clever. Now, let's take a pause here to note something very important. Fanciful, arbitrary, and suggestive trademarks are all inherently distinctive. That means that the owners of these kinds of trademarks do not need to prove how unique their brands are in the trademark application process. And this also means that by law, if a trademark is fanciful, arbitrary, or suggestive, and the trademark owner applies to register that trademark, the trademark, if approved, must go on the principal register. The principal register is the only one that gives brand owners the rights to use their trademarks exclusively and to prevent similar businesses from using similar trademarks for similar products and services. That is not the case for the fourth category of trademarks down here, known as descriptive trademarks. These rank under suggestive trademarks. Descriptive trademarks are those which use existing words that we already know to say something really obvious about the products and services themselves, the intended users of the products and services, or the business that is the source of the products and services. You should run from descriptive trademarks because they are weak trademarks that are very difficult to protect, very difficult to defend against infringement, and very difficult to get approved in the trademark application process. But the reason why these trademarks are weak is because they don't require any imagination or creativity to understand, and there is a very obvious logical connection between the trademarks and their products and services. Great examples of descriptive trademarks include things like apple pie for potpourri or mountain camper for outdoor equipment. Apple pie is descriptive of potpourri because it tells us something very obvious about the product, which is how it smells, which is like apple pie. And the smell of potpourri is the main reason why people buy it. Mountain camper is descriptive of outdoor equipment because it identifies the kind of person who will ultimately purchase and use the product, someone who wants to camp on a mountain. Unlike fanciful, arbitrary, and suggestive trademarks, descriptive trademarks do not automatically get on the principal register. That's because, again, these trademarks are not inherently distinctive. So if the USPTO approves a descriptive trademark, it will place it on the supplemental register, which does not have the benefit of exclusivity, which means that you cannot stop people from using a trademark similar to yours. However, even though these trademarks are not inherently distinctive, they can acquire distinctiveness over time if people come to associate those trademarks with specific companies rather than just general concepts that can apply to anyone. But acquiring distinctiveness is not as easy as snapping a finger. It takes tons of hard work, crazy amounts of time, and lots of money. Trademarks that are on the path towards acquired distinctiveness are also really difficult to defend against infringement, like I said earlier, because there are tons of other businesses that have the legal right to use those trademarks to identify themselves too. So it's usually a smart strategy to choose a trademark that is inherently distinctive rather than getting on the acquired distinctiveness path. The final category, all the way down here, is for generic terms. Generic terms simply describe the product or service itself, such as apple for the fruit or chair for the piece of furniture. We can even call these things trademarks because the purpose of a trademark, again, is to identify a particular business as a source of a product or service, and generic terms can't do that. All a generic term can do is identify the product or service itself. So if your trademark is generic and you submit an application to the USPTO, you will get a failure to function refusal explaining that your trademark is ineligible for protection because it is too commonly used by everyone and therefore it cannot function as a trademark. And that's because we can't give any business the ownership over the words that we all have to use to describe everyday items. And there you have it, a detailed breakdown of how to evaluate trademarks based on their strength level. What I challenge you to do now is to look at your own trademarks and figure out what category they fall into. If your trademark is in the fanciful, arbitrary, or suggestive category and you haven't applied for a trademark registration yet, what are you doing, friend? You are exactly the type of person that the trademark registration process was designed to protect. Take advantage of those protections. If you are in the descriptive category and below, you may want to consider rebranding to choose a stronger trademark to get in one of the higher categories. If you like this video, please give it a thumbs up. Be sure to subscribe for more trademark content and turn on notifications so you don't miss when I drop a new video. If you've got thoughts or questions to share, please drop them in the comments. I read and respond to each one personally, and I would love to hear from you. Thank you for watching, and stay tuned for the next video.